How long can you be married and still get an annulment? The requirements for obtaining an annulment often vary from one jurisdiction to another. Delving into the intricacies of New York's legal system, this article aims to unravel the time constraints and grounds under which marriages can be annulled. From exploring the legal definitions of void and voidable marriages to shedding light on the specific circumstances that might warrant an annulment rather than a divorce, we embark on a journey through the statutes and precedents that shape the marital dissolution landscape in the Empire State. What is an annulment? An annulment is a legal decree that declares a marriage null and void. An annulled marriage is typically considered to have never existed in the eyes of the law. This concept is rooted in religious and social traditions where a valid marriage is perceived as an unbreakable bond, and the only way to break it is to declare it non-existent from the onset. Void marriages. Void marriages are those that are illegal from the outset and therefore automatically invalid. The law recognizes these marriages as null from the beginning, and no formal legal action is necessary to declare them as such. Examples of void marriages include those involving bigamy, a person is already married to someone else, incest, marriage between close relatives, or if one or both parties are not of legal age to marry. Voidable marriages. Voidable marriages, on the other hand, are not automatically illegal. They are considered valid until a court declares them void. The circumstances that can make a marriage voidable include fraud, duress, mistake, impotency, or lack of consent. For instance, if one party was coerced into the marriage or was not of sound mind when the marriage took place, the marriage could be annulled. Annulment versus divorce. Although both annulment and divorce terminate a marriage, they do so in different ways and have different legal implications. A divorce ends a legally valid marriage. It acknowledges that the marriage existed but has now ended. Divorce proceedings often involve matters like division of property, child custody, child support, and alimony. After a divorce, both parties are free to remarry. Annulment process in New York. In New York, an annulment is a legal procedure that declares a marriage null and void. While the specific reasons for an annulment, the grounds, can vary, the process typically follows a standard series of steps. 1. Determine eligibility for annulment. 2. Consultation with an attorney. 3. Filing the annulment petition. 4. Serving the petition. 5. Court proceedings. 6. Post-annulment proceedings. Grounds for annulment in New York. In the state of New York, a marriage can be declared null and void through the process of annulment under certain specific conditions. Rather than ending a valid marriage, as in divorce, an annulment treats the marriage as though it never legally existed. There are several grounds for annulment in New York, each of which we will explore in detail. Fraud or misrepresentation. One of the most common grounds for an annulment in New York is fraud or misrepresentation. This is when one spouse lies or misrepresents significant facts to the other spouse, and these lies or misrepresentations are a key reason why the marriage took place. Lack of consent. Another ground for annulment in New York is lack of consent. This can occur if one spouse was coerced into the marriage, was mentally unfit to consent at the time of the marriage, or was intoxicated or under the influence of drugs at the time of the marriage ceremony. In each of these cases, the spouse did not or could not give free and informed consent to the marriage. If it can be proved that there was a lack of informed consent, the marriage can be annulled. Concealment of impotence. Concealment of impotence or the inability to have sexual intercourse can also be grounds for an annulment in New York. If one spouse cannot or refuses to engage in sexual intercourse and this was not disclosed before marriage, the other spouse can request an annulment. Underage marriage. In New York, an individual must be at least 18 years old to get married without parental consent. If either spouse was under the age of 18 when the marriage took place and did not have proper parental consent, the marriage can be annulled. Incestuous marriages. Marriages between close relatives are considered incestuous under New York law and are void from the start. This includes marriages between parents and children, siblings, and other close blood relatives. Such marriages can be annulled at any time by any party, even after the death of one of the spouses. Bigamy or prior existing marriage. Bigamy, which involves being married to more than one person at the same time, is illegal in New York. If one spouse was still legally married to someone else at the time of the second marriage, the second marriage is considered bigamous and can be annulled. Timeframes for pursuing an annulment in New York. In New York, the legal framework surrounding annulments is complex and varies depending on the circumstances of the marriage. While there is no strict statute of limitations for annulments, there are certain timeframes and conditions to consider when pursuing an annulment. No statute of limitations for void marriages. In New York, an inherently void marriage, also known as a void ab initio void from the beginning, is never recognized as legal, no matter how long the couple remains married. Examples of void marriages include instances of bigamy or incest. These marriages can be annulled at any point as they were never legally valid to begin with. Voidable marriages. Unlike void marriages, voidable marriages may not remain voidable indefinitely. These are marriages that can be considered illegal under certain conditions. 1. For example, if a couple marries when one or both parties are below the legal age of 18, the marriage is voidable. 2. If one party was under the influence of drugs or alcohol during the wedding ceremony but did not object to the marriage after becoming sober, and continued the marriage for an extended period, the court will likely not grant an annulment. 3. A marriage involving a party who is unable to give consent due to mental illness at the time of marriage is voidable. 4. The law does impose a specific timeframe in one instance. Getting the legal help of an experienced Manhattan annulment attorney. Understanding the timeline for pursuing an annulment in New York is crucial for individuals dealing with marriages they wish to dissolve quickly and smoothly. Navigating the complexities of this process requires a careful approach. If you're facing such challenges, getting help from an experienced Manhattan annulment attorney can be extremely valuable. NYC annulment attorneys have a deep understanding of New York's family law regulations and extensive experience with annulment cases. At New York Family Law Group, our team of Manhattan annulment lawyers can provide the guidance and representation necessary to protect your rights and streamline the path to resolution. Taking the proactive step of contacting a capable attorney can help you navigate this intricate journey confidently and calmly, ensuring you make well-informed decisions as you embark on a new chapter in your life. Call us today at 347-212-5113 to schedule a consultation.